A very good evening to all of you. It has been long since we had such a live session, but it's a new start. So let's see how it goes. A lot of people have shown interest in such live meetings, but then there comes a time when the interest wanes and we have to stop these meetings, and we will continue and stop these meetings as and when the demands are there, as and when the demands come. So taking the first question forward. The first question is from a person who has a screen name, Project Work. Sir, what is the difference between dowry list and Istridhan list? Judge passed order to return Istridhan and party submitted dowry list including groom's article, FIL, MIL and relative gift also. Any judgment? And there are more, so I'm just reading it out. And party not submitted any proof of the items. Case is an on execution stage. In DV case, 4 years of arrears are pending. She filed application for all in one shot. I have submitted objections. That CRPC 125.3. I think there are multiple questions, so I'll take one question by one question by question. So the first question is that what is the difference between dowry list and Istridhan list? Actually, there is dowry list which actually should be prepared at the time of solemnization of marriage. That is called list of articles. Dowry Prohibition Act has a section which was added, the rule which was added at a later date, which stipulated that in every marriage a list should be prepared. The list should be signed by both bride and groom and their guardians. It should list all the articles which are given in dowry, and they all should be handed over, or the custody of it should be handed over to the girl within a stipulated period of 90 days or 6 months, whichever it is. I don't recall 100%, because it is a very relatively very lesser used provision. Istridhan comes from the concept of Manusmriti, and Istridhan list is the articles which are Istridhan. Istridhan is any item which is given to a lady by her father, brother, husband, father-in-law, or relatives at the time of marriage or any time thereafter for her sole usage or usage with another person. So supposedly there is a necklace which is given, so it is for her sole usage. Supposedly a bed is given, so the bed is for joint usage of her and her husband. A car is given, it is again a joint usage. Utensils are given, it is again for joint usage. But supposedly another sari is given, so sari is for a sole usage. So all these form part of Istridhan. However, there are items which are gifts. Gift is something which is given voluntarily without other person asking. So if a watch is given to the groom at the time of wedding, it should be treated as gift and not as Istridhan, and it cannot be by any stretch of imagination be Istridhan. Can it be dowry? Yes, if there was a demand, it can be dowry. Please understand that barring few states, there is no limit on how much dowry should be given at the time of marriage as per Dowry Prohibition Act. It says that demand of dowry is illegal, exchange of dowry is illegal. However, customary gifts are allowed. Now, customary gifts, how much is custom, how much the custom allows, it varies from a place to place. So these things are not defined fully completely in Dowry Prohibition Act. There is only difference in nomenclature when a lady presents a list and she says, "This is my dowry list." In Delhi, the trend is that the lady will present a list which will include all the dowry, all the supposedly dowry articles, gift articles, istridhan, expenditure of marriage, and everything put together. This order, which says that istridhan should be returned without any bills or without any proof of these items being available, seems to me a erroneous order. It should be challenged because unless it is defined what are the istridhan items and the existence of those items are proved, further the handing over of those items to the accused or the respondents are proved, just asking a person to return these articles is erroneous to the best of my knowledge and understanding. This order should be assailed in a higher court. It should be challenged. Now, coming to other queries from project work, and the query is in DB case, 4 years of areas are pending. She has filed application for all in one shot. I have submitted objection that CRPC 125(3) allow execution only for 1 year. Judge denied and pass order to pay. With reference to Punwadi versus Thangwale 2013 10 SEC 618, what should I do? I can't pay whole amount around 6 lakhs in one shot. Is this judgment appealable? So I have not read. I don't remember this judgment. What this judgment says. So, but I'll tell you the law. The law is that execution under 125 can be filed for 1 year from the date it became due. Now, it became due is a phrase which should be seen in the context. Supposedly, an interim order is passed on 1st of January 2022 for a case which is pending since 2019. It becomes due only on 1st of January 2022, and it can be claimed within 1 year. That is till 31st December 2022, it can be claimed. This is a rule. And if this goes beyond that, then it is not recoverable by way of execution. Execution for the said amount cannot be entertained. If, and now I hope with this clarity you would have understood whether the amount was due or the areas were there. Areas could be for 4 years, even when the order is passed after 3 years, and they are all recoverable by way of execution. So you understand what it is because you know the facts. And if the areas are due beyond 1 year, then you should definitely go for revision of this judgment. One more question. On last day, she slapped me in court lobby and her brother abused my lawyer and threatened him. My lawyer bring him court police choked. They took lawyer complaint and gave her diary number. What action I can take against her and her brother? So this makes out a case of 323/506. It is a private complaint case. You want to take it forward? Definitely go ahead, take it forward. The lawyer, definitely he can take much more sterner action against her than you. But lawyers, your advocate or lawyer does not mean that he is above law or he can do anything which is beyond law. He can also claim, you know, or charge them under these relevant sections only. So I think your all queries are answered. Now I'll take another query. There is a query from a person having screen name Shyam. The lower court has given many reliefs in DVC to petitioner wife and children. Not satisfied, both parties have filed appeal in session court. Wife has filed perjury in DVC appeal after submission of affidavit in line with Rajneeshwar Sinha judgment. As I had missed sharing an asset, is that remediable? If yes, how? Is that remediable? Yes. If it is, it was mentioned in the lower court or the trial court records. It is a error, clerical error. It can be missed. It is remediable. However, if it was not available even in the trial court records, nor it is available in relief in appeal, the presumption is against you. The presumption is that you hid that information purposefully, and it will be definitely held against you. However, if it was mentioned in one particular affidavit and it got missed in another affidavit, then of course it is remediable, and you can, it can be, there can be clerical errors, and such errors do occur at times. And I'll give you a very small example that my date of birth is 24th May 1974, and there has been multiple times when I have mentioned my date of birth as 24th May 2022, 2002, 2010, because the year which is running, sometimes you tend to write that year, because whenever you are signing, you are writing that particular year. So of course these kind of clerical mistakes are possible, and some of these are remediable. Coming to the next query, and this query is from a person having screen name alert bell, and the query is: working wife left job when husband got evidence of her working. Still she is eligible. She is eligible for maintenance at the time of her evidence. She stated that she is unemployed. 125 एग्जीक्यूशन के रिप्लाई में ये बताया जाए कि वाइफ ने झूठ एविडेंस दिया और मेंटेनेंस ऑर्डर हो गया, तो क्या एग्जीक्यूशन कैंसिल हो सकती है? मेंटेनेंस ऑर्डर होने के बाद मनी ऑर्डर भेजा था, वो रिटर्न आया, रीजन एड्रेस लेफ्ट विदाउट इन्फॉर्मेशन, क्या इसका कोई बेनिफिट मिल सकता है? हस्बैंड वाइफ दोनों अलग सिटी में रहते हैं, पत्नी जिस सिटी में रहती है वहाँ मायका है, क्या सीआरपीसी 125 मायके से फाइल कर सकती है? तो अलर्ट बेल ने बहुत सारी क्वेरीज की हैं और सारी 125 से रिलेटेड है। तो 125 के बारे में सबसे पहले नीचे वाली क्वेरी लेता हूँ कि उसने अलग सिटी से 125 फाइल किया है जहाँ उसका मायका है और वो रहती है। अगर वो मायके में रहती है तो क्या वो वहाँ से 125 का केस फाइल कर सकती है? बिल्कुल कर सकती है। 125 की जुरिस्डिक्शन में जहाँ पे लड़की टेम्परेली या परमानेंटली रहती है, जहाँ पे रिस्पोंडेंट टेम्परेली या परमानेंटली रहता है और यहाँ काम करता है, दोनों, या जहाँ वो आखिर में इकट्ठे रहे थे, ये सब जगहें आती हैं। और मायके में जैसे आपने कहा कि वो रह रही है, तो क्या वहाँ से 125 का केस फाइल हो सकता है? बिल्कुल हो सकता है। दूसरी बड़ी बात जो इसी प्रश्न में निकल के आई है वो ये है कि लड़की ने यह पता चलने के बाद, आपके ये सबूत लाने के बाद कि वो काम कर रही है, उसने काम छोड़ दिया है, क्या उसे उस समय मेंटेनेंस मिलेगा? बड़ा ट्रिकी क्वेश्चन है। अगर उसने नौकरी छोड़ दी है, शी बिकेम अनएम्प्लॉयड ऑन हर ओन, देन शी इज़ नॉट एलिजिबल फॉर मेंटेनेंस। अपने आप से नौकरी छोड़ देना, अपने आप से कार्य ना करना मेंटेनेंस का हकदार नहीं बनाता है। हाँ, अगर उसकी नौकरी छूट गई है, उसे निकाल दिया गया है, तो शायद उसे कुछ मेंटेनेंस मिल सकती है। अगर आपके पास ऐसे तथ्य थे, तो मेरे हिसाब से और मेरे मानना ये है कि आपको एक परजुरी की एप्लीकेशन वहाँ पे फाइल करनी चाहिए थी। मुझे नहीं पता आपने की या नहीं की। एग्जीक्यूशन के रिप्लाई में लड़की ने झूठा एविडेंस दिया है, क्या इस पर एग्जीक्यूशन कैंसिल हो सकती है? बड़ा मुश्किल है इस ग्राउंड पे एग्जीक्यूशन का कैंसिल होना। इस एविडेंस के साथ रिवीजन में जाया जा सकता था, या इस एविडेंस के साथ परजुरी फाइल की जा सकती थी, अगर ऑर्डर चेंज नहीं हुआ है। और साथ ही चेंज ऑफ सर्कमस्टांसेस पे 126 की एप्लीकेशन फाइल की जा सकती थी। अगर ऑर्डर चेंज नहीं हुआ है, एग्जीक्यूशन मेंटेनेबल है, और हो सकता है आपको पैसा देना पड़े, आपको तुरंत रेमेडियल एक्शन लेने चाहिए। और रही बात मनी ऑर्डर भेजने की, तो उससे कोई ज़्यादा आपको फ़र्क नहीं पड़ेगा। वो स्वतंत्र है अपना स्थान बदलने के लिए, कोई भी चीज़ उसे ऐसा करने से रोकती नहीं है, तो इसलिए इससे कोई फ़र्क नहीं पड़ेगा। हितेश जोशी का सवाल है: इज देयर एनी रिलेशनशिप बिटवीन कॉज ऑफ डिवोर्स एंड मेंटेनेंस अवॉर्डेड? Is there impact when wife is involved in extramarital affair for years and engages adultery? So Hitesh, there are multiple situations and multiple cases it can impact. One of the cases could be CRPC, and I'll tell you different scenarios. One of the cases is CRPC 125. In CRPC 125, only if the lady is living in adultery, the maintenance can be denied. Merely because she has being adulterous at one or two times does not disentitle her from maintenance. And this is a law which has been laid down by many courts, also held by the many courts. Interim maintenance under HMA 24 on the grounds the husband has filed a divorce or divorce on the grounds of adultery does not disentitle the woman from claiming maintenance. She'll definitely get maintenance under maintenance pendency light because the evidence has not been taken. Under one HMA 25, that is permanent alimony, the conduct of the parties is very important. If the divorce is granted on the grounds of the adultery of the wife, more or less no alimony or limited alimony would be granted to wife. There are sporadic judgments which support that even the adulterous wife should get some maintenance or some subsistence amount. But by and large, many high courts have held that such a woman is not entitled to claim any maintenance or anything. However, both side of judgments are available, so definitely her advocate will try to use judgments which benefit her, and your advocate will try to use judgments which benefit you. So it will be finally left for the wisdom of the judge and the discretion of the judge to whether to allow or not allow alimony or maintenance. But I have seen from my practical experience that whenever a person goes with charges of adultery and can substantiate it with ample proof, woman either gets a limited maintenance or sometimes, which is though rare, maintenance is also denied. But then you have to add multiple other factors also. Now, coming to next question, and this question is from a person having screen name Green Dreams. A long list of 54 items of false is the list submitted. Can she refer to list during cross-examination? Can she be given four lists of Istridhan, all looking genuine but all wrong, and ask her to identify the correct one? Can she also be asked to write down the names of person who gifted against each? After some time, can I ask her to write down the names again, being a false list? She will not be able to reproduce. I wish, I wish this could be done. Probably in Bollywood movie it could be done. In some movies it could be done. In some fantasy land also it can be done. But no, Indian Evidence Act does not mean that you can take test of a woman or a witness in the witness box. In fact, there are times when the court allows the witness to refresh the memory because not everybody can remember everything. How you can ask about this Istridhan can be ample ways. What kind of cross you want to conduct? You want to conduct a longer cross, shorter cross, whether she has been found lying on material points otherwise or not. Couple of things which can be done. You can ask for a particular item. Can you tell me who gifted this item? And if she has listed that who gifted this item, it differs, then the advantage will be with you. However, if no names are already given, then it will not be benefiting you much. I'll rather advise go by the standard rules and art of cross examination. Read a couple of books if you are doing cross examination yourself. If a seasoned advocate is doing such kind of things, will not be allowed in court, and you should not even try that. Coming to next question, and this question is from a screen name is Abhinav Jindal. In 498 FIR, there were five people. Charge sheet was submitted only against me. Four names removed. Charged framing pending. Wife has filed application under 216 for summoning other accused. So let me understand what is 216 CRPC. So towards 216 CRPC, as I understood it about charging, other charges, various charges. So I'm sorry. This section is about adding charges and not about adding other accused. Other accused can probably be ID'd under CRPC 319, but then she will have to wait for evidence to be led before she can summon other accused. 216 strictly deals, as I understood, and I just googled it, and as I understood, it strictly deals with addition of addition and alteration of charges, right? And the said charges has to be, told to the accused. And then Vivek Goyal, did he ask a question before? No, he is a new person. Okay, Vivek Goyal has a question. The person's screen name is Vivek Goyal, and the question is, "Sir, total propaganda of wife bleeding are false, and I have documentary and photo." I think there's nothing more which he has written. So, Vivek ji, if you have all these evidences, you should file a reply and include all these evidences, both documentary and photographic, in your reply. When you are adding photographs, please understand that you have to give an evidence under 65B if they are digital photographs. Else, you need to have the negatives of these photographs which you are relying upon. I am unable to see your complete question, so this is what I can answer and what I have inferred from your question. So this answer is as per my inference of your question. Uh, Ravi has a question. Mediation center settlement says wife will withdraw her name from joint property after second motion. Sub registrar says not possible after divorce. How to remove wife name? Husband made all property payments. How to defend suit of declaration and mandatory injection by wife to take contents and operate by opening a joint locker claiming to have her the board. So they are two totally different questions. So first question is then mediation center settlement. The court in its decree should state that wife's name should be expunged from the records and it should be substituted by husband's name. Unless this order is there, uh, the sub registrar will not allow you to substitute your name from the in the records. Only it can be done by judicial order. It can be part of divorce settlement, and it can be done, but not solely based on decree and mediation center agreement. The sub registrar will do it. Sub registrar will need a judicial order to do that. Now, how to defend a suit of declaration and mandatory injection by wife to take contents and operate by opening her joint locker claiming to have her citizen gold. So, my dear friend, when you are settling the property matter in mediation center, why did not you settle all these items also? Problem comes when we do half of the things and we don't do half of the things. Of course, it can be done by seeing the evidences, and I can only tell you after I have seen the evidences what are the pleadings she has, what are the evidences you have, and how to defend it. But is it maintainable? Her injunction suit and declaratory suit, yes, it is maintainable and it needs to be fought. And you have not done right things. If the matter was settling, you should have settled all these things once and for all. Mehul Mehta has a question. Hello, Mr. Mehul Mehta here. Section 9, I got decree. My family got Bandra order was there. Need to circulate at Times of India. There was a CIL process also. And sorry, I am not able to understand or see further anywhere where you have mentioned your question. So, Mehul, you will have to write your question again because I am not able to see what you are asking. So please forgive me for this timing, and I'll take next question. Colin Ward has a question, and this is a question. Please share some good practice stroke questions to challenge false DVKs during cross-examination of wife. What questions can be asked to win the trust of the judge? So cross-examination is mostly an art, actually. There is a little bit of procedural aspects to it, but beyond that, it is an art. And coming to good practice, I have very few, like, small tips. First of all, I don't ask any questions for which I do not know the answer in when I'm cross-examining anybody. You know. So if you are going for cross-examination, you should not ask any question which for which answer you do not know. And second, there should not be any fishing. You should not ask questions which can be explained, overtly explained, because anybody can explain anything. Most of the questions should be in yes or no mode. These are few things, and then it largely depends upon what kind of allegations are leveled against you, what kind of proofs you are, whether you are confronting the witness or whether you are just going, dropping it, just asking negative questions. So there are these are few things. I have two articles on my website, that is www.shonikpur.com, about cross examination. They are quite exhaustive articles. One was written by a gentleman, Hardik Mehta, and I believe it was Hardik who has written that article and shared it with me to put it on my website. The other is I have written. So you should read those articles, and I think most of the questions would be resolved by reading those articles couple of times. Prashant F62, interesting name, and the question is, in DV, wife wrote NA in the column of B340. Uh, no or yes. It all depends what was the maintenance order, whether it was applicable, whether it was complied upon, whether the other party had knowledge that it is being complied upon. So there are a lot of ifs and buts. And 340 is a procedural thing. It is merely a procedure for punishing a person under section 191 to 199, that is about false evidence, fabricating false evidence, giving false evidence, so and so forth. So one of the things which we have to understand is that merely because the statement is untrue does not give rise to perjury or giving false evidence. The person should know that this statement, this evidence which I am giving is false, and the person should further give it on purpose. It should touch material point, and beyond that, it should be expedient in the interest of justice that an inquiry be carried on. So there are a lot of things, and I don't think that such things on such trivial matters or such small matters we should go and file perjury. It will not help your case. Colin Ward, I think you had, yes, you had a question about DV and I have answered it. So specific to mental harassment, of course, it also needs to be proved. There is a person having screen name Ramzan Ali, and the question is, what is the effect of proclamation issued by the court? In my 498A case, which is pending for 5 years, I am in US and never attended court. Court issued warrant and police came to my place in India. What is proclamation and should it be taken seriously for husband who is out of India. So Ramzan proclamation is issued when a person is not found. It is that declared that a person is proclaimed as accused and proclaimed offender, that he has done this offense and he is unable to be found, and he should be caught and produced before this court. Anybody can affect such an arrest. If you are facing only 498A, then I think the power to issue proclamation does not exist. There is a judgment to this effect, because proclamation can only be issued under limited offenses. And if you want, I can tell you, I can someday read it out to you, and you can read CRPC to understand under which section, under for which offenses proclamation can be issued. If you are not in India, this won't have any effect on you, but make sure that you don't land in India when there is a proclamation issued against you. If you land in India, you will be arrested immediately. More often than not, uh, police also tries to open lookout circular against such accused who are not to be found. And I would rather say that you should take action immediately, unless you are hell bent upon delaying the trial. You should take remedial action immediately, go for cancellation of this proclamation, and probably you will need to come and attend the court proceedings in India. Sachin MR has a question. If I prove that wife has done perjury in DV case and then got a contested divorce, and wife is convicted for perjury, will she get alimony or monthly maintenance? I don't know, because alimony and monthly maintenance are two different things. Conviction does not disentitle women from getting alimony or maintenance. Conviction on the ground that she has enough sources to maintain herself. Conviction that she was working when she gave an affidavit that she is not working will definitely have an impact, and she won't get any maintenance then. However, for any other conviction in perjury, I don't think that it will disentitle her from maintenance if she was not working. However, if she is convicted for perjury, she is sitting in jail. Of course, her expenses are limited, and so limited maintenance would be given. And I don't think anybody who is facing, you know, conviction in perjury would be willing to, get any maintenance from you. They'll rather settle the case, and DV cases can easily be settled. Mehul Mehta, you have written another line which I can see here, and it says that in section 9, I get child custody? Boy 6 decree I got. In section 9, you cannot get child custody. You will have to file another application under section 26 of Hindu Marriage Act to get the custody of child. And that's about it. I still don't get your complete question. Manoj Kumar has a question. Is wife entitled for maintenance in case of nullity of marriage? The law says that she is no longer a wife if you have gotten nullity of marriage. That means the marriage is annulled. It means the marriage never existed. Logic says she should not get maintenance, but then there are judgments which says that in the interest of justice she is not earning, in the interest of so good conscience, whatever. There are instances when court has granted limited alimony, some alimony in such cases. The chance, if there is a child born out of a marriage which has later subsequently been annulled, the child is definitely entitled for maintenance. No court can deny maintenance in such a case. Jai Bhavani has a question. Jai Bhavani has a question. Wife and husband both living in Australia, but wife filed 498 and domestic violence in India and came back to Australia for work. Both are earning equally and Indian citizen. Currently, can she file? Quite unfortunate. And this is a classic misuse of law here. Both of you don't stay in India, you don't work in India, all the incidents are out of this country. Still, Indian law can be invoked. If I were in your place, I would have challenged this summoning orders of both these cases in High Court and would have taken it till Supreme Court. This is insane, actually. And you are not alone. There would be many, many people like you who both are staying separately. I know of a couple, the lady is staying in Canada, the boy is staying in Australia. They are both contesting a DV case in Delhi. You know, both are fighting their cases on power of attorney. Both their parents come in court cases. I don't know. I don't know why these cases are running and why not people have gone for crash or why their advocates have not advised them to go for crash. But this is insane, actually. Sir, why filed 498A for 506, 509 separately? Is there a chance to club these? And this is a question by a person having screen name Chandrasekhar. And Chandrasekhar ji, if the complaints are or the FIRs are filed in the same police station, yes, they can be clubbed. If they are not, then unfortunately they cannot be clubbed because a magistrate has a jurisdiction as per the area. So only if the crimes are committed in the same area, these complaints can be clubbed. If they are not, then of course it cannot be clubbed. Or even if they are to be clubbed, it can be done only by the High Court. And I don't think for 506 and 509 you should, unless you are staying in different cities under the same High Court. Pratmesh Pawar has a question, and the question is: if my wife has cheated me by presenting herself as a doctor, cheated hospitals by working as a doctor, cheated society by enrolling her name as a doctor in marriage bureau, and has filed case against her own father 554A 554, and her father is acquitted, what are chances of me getting child custody? My child is 2 years old, my positive points, I am doctor and all doctors in my family. The chances of you getting child custody is very high. You should complain to medical council of India. You should, meet the hospital and file a criminal case against him. You should also go for annulment or divorce, whatever be the grounds. And you should also file the child custody. A woman who herself is a cheat cannot be expected to raise a good citizen of this country. The welfare of the child is not with her. The child should be taken away from her and it should be given in care and custody of a person who can take care of the child much better than her and who can make child a better citizen for this country. Ramesh has a question. Wife was working in MNC, qualified software engineer capable of 1 lakh plus per month salary, not working deliberately and extorting maintenance of 50K plus house. What are legal remedies for husband? The legal remedy of husband is to convince the court that she has willfully left her job. She is willfully unemployed. There is no other remedy actually after Rajneesh versus Neha, which stipulates whether the wife is working or not working is the sole criteria whether she should get interim maintenance or not. Hardly anything, hardly any remedy. So, dear friends, I am taking, because we are running out of time, I am taking the last question, and the question is from Aditya Arora. Wife gainfully employed, however, suppressed earning and mentioned in income affidavit she is not working. With proofs, I have filed Section 91 application and wife is directed to reply to 91 application. Interim maintenance has not been fixed yet. Wife earning 45K and my salary is 75K. Question: should I file 340 perjury application now? I want to stop the interim maintenance and get wife to settlement. Perfect case is made out for filing 340 at this point. She is gainfully employed. She is earning well. Perfect. Go ahead. Go for the kill. And chances are that she'll come for settlement. Even if she does not come for settlement, you should push your, you know, perjury application and try to, take things forward. There is a, there is a time for another question also, so I'll take it. The question is from Sanjay Garg, and the question is: I wish to seek divorce under Section 13A under HMA. Maintenance under Section 24 is anticipated once I file. Does the above two proceedings under Section 13A and 125 affect each other? Note: I am already paying 2K maintenance per month in DB. Do they impact? No. Independent applications, independent cases. So, and 13 case under Section 13 of Hindu Marriage Act is a case for divorce, and divorce is an independent remedy. So take your own sweet call about it. She'll definitely file HMA 24. She may file Section 125 also, CRPC 125 also, but then these cases needs to be fought. So friends, so far so good in this meeting, and I just wanted to reiterate a couple of points, and that is why I took a couple of minutes extra. Sahodar conducts two weekly meetings in Delhi. One happens in Connaught Place, the other happens in Rohini District Park Court. We also run a very vibrant WhatsApp help groups. Our help groups are defined by the stage of the cases. To enroll in these WhatsApp groups, you need to send a WhatsApp message with subscribe to 98118 50498. Let me repeat, the number is 98118 50498. Another thing which I wanted to, extol or tell everybody of you is that if any of you is willing to start a men's right group in their area, then Saudar is willing to help them. You can again send a WhatsApp message. All help will be provided to you to start, and of course, a lot of people will be told about these groups which will be starting in smaller cities. The groups are available in bigger cities, metros, but smaller cities also need a lot of groups. So only if there are groups in each of these small cities, probably we'll be able to make some changes. So we'll try to continue these sessions on a weekly basis, and if there is demand, next week again we'll definitely meet. I have not been able to complete the questions, and I can see there are a lot of questions available. So all these people, gentlemen, please do come back again next week, and we'll meet again. I'll try to take your questions. Thank you very much.